now going to move on to copyrights. What is a copyright? What's it protect? How do you get it? What are the rights of the owner? How long does it last? Who owns it? A copyrighted work is any original creative expression fixed in a tangible medium. That's the definition. There's a lot of subtle words there. So how about my presentation right now? These magic words. Are they protected under copyright? Wait, somebody says yes. Well, actually, typically it isn't, but today we're actually filming this. So it is fixed in a tangible medium. But when I teach this at like Pasadena City College, nobody's filming it. So in those circumstances, there is no copyright protection because it isn't fixed. Then I asked the question, what about my slideshow up there on the screen? And the answer is yes, it's fixed in my computer. It doesn't have to, those little zeros and ones may not be readable directly by a human being, but they are interpretable, and that's protected. Now, if I had a whiteboard here, I put up a happy face, and I say, is that protected under copyright? And the answer would be no, that's not very original. And then if I had the whiteboard, I'd scribble all over it and make a human being stick figure out of it and something that was originally original, and then I ask, is that protected under the copyright statute? And the class always answers yes, and then I take my eraser and wipe it away, and I say, this is not very fixed, is it? And the answer is no. Okay, so there's a lot of words in there, but those are the key. An original creative expression fixed in a tangible medium. What can be protected by copyright? Well, it's probably pretty intuitive. We're talking about printed matter, for example, books, of course, but software is protectable. Business proposals, databases, catalogs, manuals, all protected. The notes you're writing right now, if you're writing notes, those are all protected by copyright. Artistic works, such as computer screens, sculptures, audiovisual works, photographs and pictures and ads, Hollywood movies. How do you get copyright protection? Very easy. Automatic. As soon as you have original work, original creative work fixed in a tangible medium, there is copyright protection. You don't have to do anything more. No requirement. It's not like a patent where you have to run off the patent office and say, please, please, please give me a patent. It's automatic. Now, there's certain things you should do. For example, put a notice of copyright on the work. Pretty cheap. Here's an example. One of our clients, Southern California Edison, all it is a C with a circle around it and the year it was first published. That's optional, but it's recommended to avoid somebody being an innocent infringer. Another option is to register the copyright with the Copyright Office. And there's at least 3 good reasons for doing so. One is there are some courts that hold you have to have a registration in place before you can sue for infringement. So if there's an infringer out there and you don't have a registration in place, it could delay the process. The second reason is there's something called statutory damages, which can be sizable. If you can't prove if you don't want to prove your actual damages, the statute says, well, you can get this amount up to this amount. And if you read in the newspaper about these people that have been illegally downloading music getting sued, the record companies are not saying, please give us the 30 cents we would have gotten if you downloaded on iTunes. No, we want statutory damages, and they're getting awards of hundreds of thousands of dollars. So this can be significant. And the third reason is very, very dear to my heart. There's a presumption, if there's a copyright registration in place and there's infringement, the owner of the copyright gets their attorney fees. And that's, besides being dear to my heart, it's a big hammer over the defendant, because for every dollar they spend defending the case, they end up actually paying $2. What are the owner's rights in a copyright? Well, there's a lot of different rights depending on the type of work, but as you would expect, the right to reproduce it, the right to commercialize it, and something called prepared derivative works. And I got sort of an example up here. That's a little poster for the movie Gone with the Wind. But the original work was the book. And they couldn't make the movie without a license from the owner of the copyright in the book because they're creating a derivative work. How long does a copyright last? Long enough. In my view, too long. The life of the author plus 70 years. Or if it's a corporation, 95 or 120 years. It used to be 2 terms, each of 14 years. It used to be 28 years. And then Mickey Mouse came along. And literally, the copyright in Steamboat Willie, the first Mickey Mouse cartoon, was going to expire, and Disney didn't want that, so they kept lobbying Congress time after time after time. It got the term extended and extended and extended, and that's what it is now. the constitutionality of this was challenged because the Constitution says, authors get the right to their works for a limited period of time, but the Supreme Court said, Congress says this is limited, so who are we to argue with them? Who is the initial owner of a copyright? This gets a little bit tricky under U.S. law. As you would expect, like inventors initially own a patent, the author initially owns a copyright. But who is the author? The person actually doing the work, with an exception, is the author, and that exception is what we call work for hire. If it's an employee preparing the work in their ordinary employment, as part of their employment, not only does the employer automatically own the copyright, the employer would actually get listed on the copyright registration certificate as the author. So whoever actually did the work is totally anonymous. And like any other piece of property, it can be sold or assigned. So the copyright can be assigned. This is an easy one. How do you avoid copyright infringement? Don't copy. Simple as that. So that if, I like that flag out there, take a picture of it. Okay, somebody sees my photograph. They like my photograph of the flag. Don't copy my photograph. Go take your own picture of the flag. And there's some exceptions, but in general, go to the original. If you like my little piece of jewelry based on a bee, go make your own using a real bee as your impetus. Don't use my bee. So don't copy. Independent creation is okay. It's what we say, copy the original. Don't copy the copy. In the software area, this can get tricky. Let's say somebody has a better system for billing from dentist offices, a better dental software, and you want to compete with that. Well, you don't want to be accused of copyright infringement. So what you can do is you can say, okay, here are the functionalities. We want these functionalities. You take these functionalities to somebody else and say, you write the code, you write the software, and make sure that person has never seen the original software. So they could not possibly have copied it. That's what I call a clean room operation. So that's a way to avoid copyright infringement. Those of you who were married and had a photographer there got the rude awakening that even though you paid the photographer owns the copyright in those pictures. And if you wanted more copies, you had to pay for those. And that applies across the law. So that if I hired an advertising agency to do an ad for me, they own the copyright in it, unless I have a written assignment. And we see a lot of cases where the person thinks they own the copyright, the company thinks they do it, they do the ad and they say, boy, that was a great ad. You know what, we're going to make a billboard out of it. And next thing they know, they get sued for copyright infringement because the license they got was limited to the ad, not for use in a billboard. So whenever you work with outside people in terms of creating works, you want to get a written assignment. For example, the photographer right here, we have a written assignment in the copyright. That was part of the deal in exchange for the check. Copyright versus public domain. If something's in the public domain, there is no copyright. When does that occur? If the copyright expires or U.S. government work. I'll give you a very practical example. We're putting together a brochure here on copyright law. We have them on trademark, we have them on patents. We haven't done one on copyright. I downloaded the brochure from the Copyright Office and I'm cut and pasted. I mean, they said things pretty well. I changed a few things here that I don't think were right and picked the best parts, but it's free. Anybody can use that. That's not copyright infringement. U.S. government works aren't copyrighted. The mere fact there is no copyright notice doesn't mean it's in the public domain. As I told you, that's an optional thing to do. So you can't assume just because there's no copyright notice it's in the public domain. But I'm going to briefly mention what I call the open source issue. There's free software out there, open source, so you don't have to reinvent the wheel, you know, procedures, calendar, programs, stuff like that. And they say, please use me, it's free. But it comes with a license. And that license says, oh, by the way, you give up all the intellectual property rights in your software because you used our little piece. So you got to be very careful to use open source. I'm not saying don't use it, but if you're writing something, if you're doing some computer code, be careful, and particularly if you hire outside programmers, either require them to not use open source software, or if you are going to let them use it, be aware of the risk. So what key points on copyright to take away? Copyright protects original works of authorship. It's automatic, but notice and registration are desirable. Get the assignment of the copyright from vendors and avoid open source software. That's it for copyrights.